Welcome to the Business SOS podcast. This is Rich Sierra, president of Florida Small Business Legal Center. This is episode 138 of the podcast as we continue working our way to episode 200. I'm very excited about that. So today we have a special guest with us. I have a colleague and a friend. He's a business litigation attorney who we have worked together in many cases. He's also a mediator and an arbitrator. I welcome my friend and colleague, Matthew Fornaro.
Rich, thank you for having me. Glad to be here. Excited.
Matthew, and happy birthday.
Thank you. My birthday was yesterday. I'm old.
All right. No, I'm old.
I'm old.
Yeah. So, Matthew, I've been wanting to have you on our podcast for some time, and finally our calendars finally aligned.
Finally.
To be able to bring you here. So, I've done episodes, as I mentioned to you before, on mediation, arbitration, but I have not had a mediator and arbitrator actually come in and talk to us. But before I do that, tell me a little bit more about your practice. It is Fornaro Legal. Is that correct?
Yes.
Okay. And you do kind of the same thing that I do, but tell me more about your practice. Let's start with that.
Sure. So I've been an attorney for 23 plus years. I've had my own firm, as you know, for almost 11 years. I focus on small businesses, entrepreneurs, and startups regarding all their legal issues, whether it's transactional or litigation. And that's essentially my practice. That's my wheelhouse, and I stay in it. I don't get out of my lane. I stay in my lane.
I know. We both do have pretty much the same practices.
Yeah, exactly.
We can have another episode on war stories.
Exactly. We have a lot of war stories
to share. So I want to talk about mediation in this case because I'm a big proponent of mediation, and I want to have our listeners to hear from an actual mediator that practices mediation. So let's start from the very basics. So what is mediation?
So mediation is a form of alternative dispute resolution. So it can be within a court case, there's mediation that you have to do. Within an arbitration, there's mediation you have to do, or pre-suit or whatever, you can do mediation. So mediation is, again, one of the forms of alternative dispute resolution. It's where there is a neutral mediator who facilitates parties trying to essentially settle a case. So here's what happens. You have a neutral mediator who much of the time is an attorney or a former judge. Better yet, those are the mediators that I like to use myself personally, are former judges. And they're, well-versed in whatever subject matter you have your mediation in. So you always try to pick a mediator who has been involved in cases like yours before. You don't want like a family law mediator for your business dispute, or you don't want, something, whatever. So then what happens is you set up your mediation. In this day and age, it can either be in person or it can be on Zoom. I personally don't care. I love Zoom, so I'm cool with Zoom. A lot of people still want to do it in person, which is fine. I mean, I had a mediation 2 weeks ago that lasted for 12 hours in person at the Gray Robinson office in Brickell on a Friday. I didn't get out of there till 10 p.m. So you can do it in person, you can do it on Zoom. So what happens is you have, your mediator, then you have your plaintiff or claimant or one side, and then you have your defendant or your respondent or the other side. And then they show up at the mediation, whether it's in person or on Zoom. Before the mediation, obviously you want to plan and do everything. So a lot of the time you send the mediator like a synopsis of the case, you send them the pleadings, you send whatever, you send your spin on things, you send what your settlement goals are. Maybe, you don't show your full hand, but you tell them, I'd be willing to take X amount of dollars for this case or whatever. And then obviously you also prepare with your client to go over the mediation process so that they understand what's going on and they understand what mediation is and what mediation isn't, which surprisingly, sometimes it's very hard to have a client understand just what is going on in mediation or whatever, because they get a lot of preconceived notions or whatever, particularly, whatever, when I'm the mediator and they come in and they're unprepared, it's very interesting to try to explain to them, no, I'm not doing this. No, I'm not doing that, because the mediator is a true neutral. They're supposed to be unbiased. They don't make findings of fact or conclusions of law.
Correct.
They're not supposed to, if it's done pursuant to the Florida rules of civil procedure, they're not supposed to comment on how great your case is, how terrible your case is, or anything like that. They're not supposed to do that. They can give you an evaluation where they say, I've seen cases like this, and I've seen cases go this way or that way, but they can't say, Rich, your case is crap, or, Rich, your case is great. So you show up at the mediation, hope you've been prepared. You understand what's going to go on. You show up, you're all in one room, whether it's in a Zoom room or a real room in the real world. And you have your initial opening statements, generally speaking. So then the mediator will say, I'm Matt Fornaro, I'm a mediator. Here's my background. Here's what the mediation process is. And they explain mediation where they're neutral. They're not finding fact, conclusions of law. Everything that's said is totally confidential.
Yeah.
Nothing that happens at mediation leaves mediation. Be cordial, be nice towards each other. I understand it's hotly contested no matter what kind of case it is, but still, be nice. You don't have to be mean or whatever. And then they just go over the general ground rules of mediation. Then generally you have one side makes an opening statement. The other side makes an opening statement. Sometimes you waive opening statements if it's like very hotly contested to just kind of, because, I'm right, you're wrong. I'm smart, you're dumb. You don't need to say that to the person's face, particularly if it's very animated or whatever. So then you have your opening statements, and then from there you split up and you go caucus. So, I'll just say plaintiff for lack of a better term. You have the plaintiff and their entourage goes in one room, and you have the defendant and their entourage goes in the other room. So you're supposed to only have, your attorney, the parties, if they're individuals, and the corporate representative. You're not supposed to have mom there for support, or, your uncle who, dropped out of law school who maybe can advise. They're not allowed to be there. It's only key players. So then the mediator goes back and forth and tries to essentially facilitate you getting to a deal. And again, it's all totally voluntary. No one's making you do anything you don't want to do. The mediator has a conversation with you and discusses your case and what it is you're looking for, what it is you want to do, what it is you'd like to see would happen, what your claims are, what the defenses are, the counterclaims, anything like that. Then they go to the other side and they talk about the same thing. And obviously everything they say is confidential unless you tell them to tell them something. So if I tell you, Rich, we'll settle this for $1 million, but don't tell the other side. Mediator can't tell the other side. But if I say, Rich, tell them we'll settle for $1 million, they'll go tell them they settle for $1 million. So then the mediator tries to get the people over the course of time to go back and forth to come up with solutions to try to resolve the case. Sometimes it's not what you think it's going to be. It's going to be a totally different alternate, theory on whatever. It's not, you show up there, you got your hand out looking for money, and then you leave there with like a licensing agreement or something totally, whatever. Different. So you go back and forth, and then eventually, you either work towards a resolution, again, totally voluntary. No one's making you do anything you don't want to do. Try to get to yes. And if you can't get to yes, then, and it's not going to settle, then you have an impasse. And what an impasse is means we tried, we just can't settle the case. So then the parties go about their business. Either if it's pre-suit, then they file suit. If it's arbitration, they go back to arbitration. If it's litigation, they go back to court and proceed forward with the case. The mediator sends in a mediator's report that says the case wasn't settled. Here's who attended. And that's it. The mediator is done with the case. Or if the case settles, then depending on the circumstances, you can have the mediator draft up a settlement agreement. You can have the parties draft up a settlement agreement. And you work on your settlement agreement with all the key terms and everything. And then you reduce it to paper, and then it becomes a contract between the parties that they agreed to resolve the dispute. So instead of it being whatever, it's a contract that says, I'm going to do this, you're going to do that, I'm going to pay this, you're going to pay that, we're going to do this, whatever. The case is going to be dismissed, or we're not going to file a case, or the arbitration is going to be dismissed. And that is basically it. Those are your options. That's kind of mediation in a nutshell. Obviously, that is a super simplified view. It gets incredibly complex, and there's a lot of moving parts that can happen. A lot of things can happen. One of the things, though, I can tell you from being a mediator and having dealt with this as an attorney as well, is that, there's this whole concept of, and it's becoming more prevalent I've seen, at least in my practice, of a lot of people trying to get out of deals that they make or modify deals after the fact.
Yeah.
So one of the things when you're in mediation or whatever is that under the Florida rules of civil procedure, so if it's a state court case in Florida, the rules in the case law say that unless you have a signed agreement there at the mediation, you do not have a legal resolution. So later on, if you guys are like, oh, I'm tired, here's what it's going to be, we'll go home and draft it, wherever. Later on, if someone wants to repudiate that or say that's not my deal, that can fly. They can get away with that because you didn't sign it at the mediation. The federal rules slightly different. They're more apt to enforce a settlement agreement. Non-litigation mediation, it's more like a contract theory. So was there a meeting of the minds or whatever? So the moral of the story is that if you can do it, it would be great when you're at a mediation to reduce to writing, finalize, collaborate back and forth, and have a signed mediation agreement. So that way it's done. There's no doubt as to who does what or whatever. I've seen, that's the best practice. I've seen other people where, at the end, the mediator will get everyone together after they explain to the plaintiff or they explain to the defendant what the deal is going to be or whatever. And they all get back together in the same room. And even if they hate each other or whatever, they still get back together. And they're like, here's the deal. Do we all agree this is the deal? Yes. And the mediator will send out essentially a self-serving email that says, here's the deal. You guys are going to write up the settlement agreement, whatever. So that's better than nothing, but it would be better to have the settlement agreement written
signed
down.
by the parties.
Yeah. Signed by the parties or the people. And, that way there's no doubt as to what happens. Because I've been involved with, as the attorney, in the last probably the last 3 years or 2 years, I'll say, I've been involved in 3 cases where my client repudiated the mediation, the opposing counsel and the opposing party in another case repudiated the mediation, and then another case where the attorney was fired by his client because the client wanted to get out of the mediation and the attorney wanted to go along with it. So they got in a replacement attorney, and the replacement attorney is now attempting to repudiate the mediation deal. So, the moral of the story is when you go to mediation, you want to walk out with a signed document. I don't care how late it is. I don't care how tired you are. You went through the process. You might as well finish it the right way and have the signed agreement before you leave. That way there's no issue. And that's, in a nutshell, that is mediation.
Yeah. Well, thank you. I've learned that the hard way many years ago that the parties were tired, said we're going to sign this, we're going to send drafts. And then one of the parties did not sign it. I don't know if it was my client or the other side. No. But yes, I think you got to sign it there.
Yeah.
And I prefer doing my own agreements.
Yeah.
It's faster. I know the agreement. Mm-hmm. When somebody else drafts the agreement, then I have to go through. It's a longer process because it's not my agreement. So I have to really go through every single line. When it's my template already paired, and we already have, for my mediations, I already have a standard agreement template already, and leaving out the agreement, the key points that the parties agree to, blank.
Yeah.
But everything else is already there, the releases, so it makes the drafting process a lot faster.
Yeah.
So I'll tell Richard, prepare a template, we have it ready, in the case that this case settles. Mm-hmm. So what are the benefits of mediation? Say somebody's in litigation right now, and what are the benefits for them to go into mediation?
Sure. So, litigation is a time and money consuming process. Even when you're the winner in the end, you're still going to have spent a lot of time away from your business, away from your life doing stuff. So the sooner you can get out of litigation, even if you're, the winner or whatever, the better. So mediation allows you to try to resolve the case sooner rather than later, and to get out of litigation or to get out of arbitration or to get out of a dispute. So the benefits is that it gives you an open forum where, you can go in front of an impartial mediator and, present your case. And again, the mediator's not or shouldn't, comment on, hey, Rich, it's a great case. I think you're going to do well at court or whatever. But they can be like, Rich, I've seen cases like this and here's what's happened. I've seen cases that go this way and cases that go that way. So when you do mediation, it gives you the opportunity to resolve the case sooner, resolve the case cheaper, gives you an opportunity to have a second set or a third set of eyes look at your case in the form of the mediator to be like, well, why don't you think about this or think about that kind of thing, again, without commenting on the strength or weakness of your case. And then it also allows you to interact with the other side in a kind of dynamic forum where you get to see, during the mediation, like what their defenses are going to be or what their fallback position is going to be or where they're willing to go or not go in the course of the case. And again, confidential, but still you get to see, this guy was going to pay me $50,000 today. And I said, no, will he pay me $100,000, a few months from now, or will he pay me 25 a few months from now? So you get to kind of see each other's position. You get to see your position. You get to focus a little bit more on your position because you have to present it to a third party, although not the court, a mediator. So it helps you focus. It helps you do things. And again, it can help you resolve the case sooner rather than later. And it allows you to be in charge where you either agree to an agreement that you want or you don't. You don't get left with whatever the court rules. So that's why every federal case, every state case in Florida, and every AAA arbitration, JAMS arbitration, and NAM arbitration requires you to go to mediation before you go all the way forward with litigating or arbitrating a case.
Yeah. And I think one of the other benefits is that this is the only opportunity the parties have to resolve the case on their own terms.
Correct.
Because the reality is somebody's going to make the decision.
Mm-hmm.
And when you go to court, there'll be a winner, there'll be a loser. There's no draw here. So when I tell my clients, this is your only opportunity. And in reality, you are in charge.
Mm-hmm.
We are there to assist. We're there to provide advice and give some guidance. But ultimately, if the case resolves because the parties agreed to resolve the case, not because we were the ones, making that decision.
Yeah.
How can clients prepare for mediation?
It's interesting because, with the AI guru, I don't have to tell you, clients are now more attuned to trying to figure out things on their cases and do their own legal research and their own AI research. So, which is interesting because sometimes it's helpful and sometimes it's not. So when preparing for mediation now, I get a lot of, from the attorney standpoint, I get a lot of clients who are doing their own preparation outside of what I'm telling them to do. And it's not necessarily very beneficial or whatever. From the mediator standpoint, I see a lot of people who are clients trying to do their own research and stuff. And it's, again, not very beneficial or very, very often left field, looking for very sectarian things to talk about or whatever. But I mean, to prepare for mediation, I mean, you have to, if it's a business dispute, like most of the stuff that we deal with, I mean, the business owner or the person who owns a business or the employee or whatever it is, I mean, they have to think first from a business perspective of, when I'm involved in a case or I'm involved in an arbitration or I'm involved in a dispute, that takes away from me being able to work on my business and make money. So they have to prepare from the standpoint of here's an opportunity to get rid of this and get back to focusing on your business. Yeah. So when I tell them to prepare, we prepare all the nuts and bolts stuff, but also from the metaphysical standpoint of, get ready to make business decisions and make good decisions that ultimately may cause short-term pain or may not be exactly what you want. But in the end, it gets you back doing what you do, which is focus on your business or focus on your career or focus on whatever. So, to prepare, obviously, review all the documents, look over your pleadings. Please review your pleadings. Know what you've actually pled in the case. Know what the other side's pled. Look at, your emails, your text, your evidence and all stuff like that. Meet with your attorney. Go over what your strategy is going to be. Have a, bracket or whatever you want to talk about of where here's your high number, here's your low number. Or if there's other things that are non-monetary terms, figure out what are must-haves or things that would be nice to have or not have. And just figure out the paradigm for what you want to do at mediation as far as what would you like to see leaving mediation versus what can you bear to live with leaving mediation. And that's generally how you prepare for mediation.
I think that's very important. I think that from the client perspective, they need to really understand the facts. They will help us with the facts. I mean, they live this case. We did not. We know the case from the concept from the perspective of the interrogatories, depositions, the text messages, the emails. We kind of reconstruct what happened that led to that litigation as a result of all the documents that we receive and whatever a client tell us. But they lived it.
Yeah.
The client lived that, and sometimes they can provide us details about something that took place that we were aware of.
Yeah, correct.
So understanding those facts are key because that will be helpful to us.
Correct.
We know the law. They don't need to give us ChatGPT or any type of, research. We got that.
Yeah.
But the facts are theirs.
Yeah.
When I prepare my clients, I actually do a mediation prep. Now what I actually do, I send them a copy, a link to my podcast about how to prepare for mediation. That saves me a great deal of time.
Yeah.
But in addition to that, we go over some strategies and tactics. And one of the things that I emphasize is that when the mediation comes in with an offer, and that's what happens usually, and I have certain guidelines. I like to see some movement within an hour and a half of the mediation. That's my preference. If I don't see any movement, I begin to say, okay, we're going to begin to shorten this out because there has to be some movement somewhere. When the mediator comes in with an offer, I tell them do not react to the offer. The first offer is going to be no, and it's probably going to be something that is going to be insulting. But do not overreact, and we just let the mediator leave the room so we can talk privately. And then to have the discipline not to say anything when the offer comes in, and just say, and to know that they don't have to discuss any type of discussions with the attorney in front of the mediator. We can let the mediator leave the room, it's virtual or in person, and then we can talk about what the offer is, and then we can prepare a counter offer. And having that discipline about when to share information, when not to share information. The mediator needs to have they need to have a basis, they need to have the facts. But the mediator also, they're trying to put a deal together. And that's I've never done a mediation from a mediator standpoint, but they're trying to put a deal together. And I had one many years ago. It was in person. That was way pre-COVID. In fact, I was at the same office building that you were in.
Yeah.
In Heron Bay.
Yeah.
So that was way, way back. And the mediator went back and forth, and he went in with an offer. My client said, I will take this amount. And the moment he said that was over.
Yeah.
Because the mediator already knew what was the max he would take.
Yeah.
And that's the max we actually settled for.
Yeah.
Even his wife yelled at him.
Yeah.
So why are you saying that for?
Yeah.
So one of the mistakes that sometimes clients make, they get overreactive and they share things without consulting it with the attorney in front of the mediator.
Yeah.
And there's nothing, listen, it's okay to share with the mediator, but controlling the information and when the information is presented is very important because the mediator is trying to put a deal together and we do not know what the mediator learned from the other side.
Yeah.
Do you agree with that?
No, I agree. I mean, from litigating, at this point, literally, I can say thousands of cases. Yes. Okay. I've seen a lot of stuff go down. So from the mediator's standpoint, I have seen hundreds of mediators over my career. So I have my opinion of what makes a good mediator and what makes a not good mediator. And like I said, I like using former judges for the most part as mediators because I think they do the best job. A lot of people have different disciplines or a lot of, different preferences or whatever. And, I'm fine with whatever. I get involved in cases where people try to really push an agenda and push mediators on you. And, I'm pretty amicable to that for the most part. But, some people really want like a plaintiff's attorney or a defense attorney or whatever. And again, from my perspective as a mediator, I want to try to facilitate a resolution. Okay. And having seen from the litigation standpoint, all the different mediator styles and all the different things, whatever, I'm not the kind of mediator who will just, do like a Henry Kissinger back and forth shuttle diplomacy thing where, you're going to go up $50 and then I'm going to come back and go down $50. I'm going to go up $50. And I've been involved in many mediations like that. And it's ridiculous. I like to keep it moving. And like, I'm not making you do anything you don't want to do, but let's try to get to a resolution. I generally, I pretty much understand what's going on here, what the cases are about or whatever. Let's try to facilitate a resolution in a, more timely than not manner. And we can pretty much figure out if you're going to be in the ballpark that they want to settle in and they're going to be in the ballpark you want to settle. We don't have to do this. I go up 500, you go down 500. I go up 5, total waste of time. And
yes,
like I was telling you, I was involved on the attorney side. I was involved in a 12-hour mediation.
That's insane.
In person 2 weeks ago. I'm not going to get into the details, but it was a lot of that just back and forth, and a lot of time and it was just total. I would have, as the mediator, I would have totally handled it differently. But, that's my style. People may or may not like it. It may or may not be effective, but I can tell you, I like doing things that way and it works for me. I try to get, things going in an expeditious manner as opposed to wasting everyone's time, because you can figure out pretty soon from a mediator standpoint if a case is going to settle or not, depending on the willingness of the parties, the creativity of the parties, the objectivity of the parties, versus, some people are really dug in and really obstinate about what they want to do. And it doesn't matter if we spend 1 hour or 12 hours, it's not going to settle. All right. So I'd rather we all move along and do whatever and save everyone a lot of time and effort rather than go back and forth and be whatever. But at the same time, if we have to take time to do it, then we'll take time to do it.
Some people are punching in too. They just to meet the requirements of the court.
Yeah. And a lot of people, show up. The requirements for mediation is like,
show up.
You're supposed to show up and negotiate in good faith. And what that means, I don't know, because I've seen, people show up where it's like, here's my top offer, I'm done. And okay, I guess that's good faith or whatever. You showed up and you made an offer that wasn't what you're seeking. So I guess you compromised or whatever. But, some mediations just aren't going to go anywhere. And the sooner you figure that out, the better it is for everyone, rather than trying to, beat a dead horse. It's not going to come back. It's dead. It's not happening.
Yeah. It is also beneficial. I like it simply because it gives me an opportunity to know about the other side's position as well. Mm-hmm. And for me, when I do the opening, it's the only opportunity that I have to speak directly to the other party outside of a depo, which is more structured, or in trial, which is a direct or cross-examination. But there I can actually present our case. And it's the first time that they will actually meet me as the opposing attorney. So they kind of gauge, okay, this is the attorney I'm going against. So it is an opportunity to introduce myself and tell them this is our case. I have a few more minutes before we wrap up this segment. You mentioned you prefer judges for mediators. Why is that?
Because, judges have seen and done a lot. Okay. They've seen your kind of case. They've seen it go one way. They've seen it go the other. Even though, again, if it's done pursuant to the Florida Rules of Civil Procedure, then it's supposed to comment on the strengths or weaknesses of your case, but they can tell you from years of experience, I've seen your case go here and I've seen your case go there. So they don't bring a partisan bias, to the thing. They're just there to call balls and strikes, even though they're not supposed to be calling balls and strikes. When you use certain attorneys who, like I say, have certain backgrounds, they have an unconscious bias towards their background, whether they know it or not. And I've seen it happen in many mediations where they cross the line and they start commenting on your case, or they start trying to steer you in one direction or another. And, I just have seen it happen too many times where I just, don't want to deal with that. And most times when you deal with judges, you're dealing with, people who've seen and done it all, and they present information in an objective way, and they don't have a bias, or they don't have even an unconscious bias. I'm not saying, the mediators are biased. I'm just saying in their mindset, they've seen it from one way their entire career. And are they going to now move to the other way and see it for this in your case, which is probably not, but judges have seen it from both ways. So that's why I like doing it. The judges have a lot better control over the parties and stuff as far as the actual process of the mediation goes. They have a lot more gravitas or whatever, a lot more deference.
Yes.
I think people are a lot more candid with judges too when it's caucus time versus just, like in a regular attorney or a regular mediator. So that's why I like using judges. I mean, there's great non-judge mediators out there too, but my preference personally from the litigation standpoint is I like using former judges. They cost the same amount, although some of them are very expensive, but a lot of the judges are the same price as, a non-judge mediator. So, I mean, it's not like it's, for the most part, a price difference or a price point difference. And I think generally speaking, you may or may not resolve the case, but you'll get a more productive result by having a judge as a former mediator or a former judge as a mediator.
Yeah, yeah. You also, the price is it's a little bit more in some cases, depending on the case. Someone tells you a judge or a regular mediator.
Yeah.
Especially depending on the amount of the controversy and the complexity of it as well.
Yeah.
My rule is that I work with anybody as long as they prepare.
Yeah.
They need to prepare and read the material.
Yeah.
Not show up there and say, what is this all about?
Yeah.
We both have seen that before, and it just becomes very frustrating.
Yeah.
So Matthew, how do people find you?
Well, check out my website, which is fornarolegal.com, which is my last name, legal.com. It's got all my contact information on it. It's got all my social media. It's got all my blogs. It's got all my podcasts that I've been guests on. It's got my white paper. It's got a lot of information for, small businesses, entrepreneurs, and startups regarding transactional stuff, litigation stuff, mediation, arbitration. It's all on there.
Thank you. Thank you very much. I'm glad you have time to do another segment with us.
Yeah, I'd be glad to.
All right. Thank you. Let me close the show the way I usually close it. Thank you again, Matthew, for joining us today.
Thank you, Rich. I was glad to be here.
This is exciting. And for anybody who wants to have a question about this podcast or any other podcast, my email is rich@richsierra.com. If you want to give us a call, my number is 866-842-5202. My website is floridasmallbusinesslegalcenter.com. We're in Facebook and Instagram at FSB Legal. If you want to see the video of this podcast, we're at youtube.com/@Richard Sierra. Remember my book, Business SOS, 8 Common Legal Mistakes Business Owners Make and How to Avoid Them. It's available on Amazon, Barnes & Noble. You can ask for any local bookstores as well. Until next week, this is Rich Sierra. Remember that my goal is to have you succeed.